My name is Dr. Tom Whitcop. I'm a psychiatrist living in Brainerd, Minnesota. I was asked to comment on a film clip earlier today that I witnessed. The clip in question showed me a gentleman who had talked about seeing several individuals that apparently had mental disabilities and were taken as a group to an absentee voting booth where each one of them was assisted in voting by the staff person from whichever facility this must have been. And we're not even sure, it wasn't stated whether this actually was a staff person from a facility, simply someone who was bringing these people to the absentee voting booth. And apparently these individuals appeared very incompetent, according to this witness, and the concern was whether or not that was actually legal, whether or not this individual who apparently helped them not only fill out the ballots but also told them which individuals to vote for, whether that was legal, appropriate. Well, obviously I'm a physician, I'm a psychiatric physician, I'm not a lawyer, but I think in the context of that experience, I can at least try and give some background that might help judge whether or not what occurred was appropriate, legal, etc. In Minnesota, the state has been, I think, quite good at seeing to it that individuals who have what we call developmental disabilities, and that's a newer term for what used to be called mental retardation. But individuals that have developmental disabilities are given many assistances. And one of those assistances has been to make sure that they have appropriate guardianship availability. Now, guardianship in the state of Minnesota is a legal process in which a judge determines, after being given appropriate facts, that an individual is not capable of managing their affairs, either physical, financial, or day-to-day, in a manner that is in their own self-interest. And when that occurs, the judge may then appoint an individual that they term a guardian. And that guardian then is the legally responsible person to manage that person's financial, medical, and general welfare materials. Now, individuals that are determined through the Department of Human Services to be developmentally disabled would pretty routinely have a guardian established for them through this process. And that individual, sometimes a parent, sometimes a relative, sometimes an attorney, sometimes a social worker, whichever the court, the judge, determines, that individual would then be a regular part of their life on an ongoing basis as they need any decisions made about medical care, financial assistance, financial services, living arrangements, etc., etc. Now, the state of Minnesota, in its constitution, determined that individuals who were developmentally disabled would not be eligible to cast votes in elections. However, apparently the state at some point in time, and I'm afraid I don't know the exact year, established a statute that appears to have overridden that constitutional article, such that there is now a statute that can determine, that states that an individual who is developmentally disabled still has the right to vote. Now, that seems unusual to someone who has worked in the field for 40 years, but nonetheless, that is what the Minnesota statute apparently states, at least as I've read it. What we had in the interview that I saw, however, I think was not as the Minnesota statute would determine to be legal. These individuals apparently were brought to the voting booth by either a simple staff person or a driver, and none appeared to have been accompanied by a personal guardian, which, in the context of affording them an opportunity to vote, and noting that their incompetence determined that they must have a guardian, would seem almost imperative that that guardian would accompany them to the voting booth such that their best interests, and the court determines that the guardian has their best interests at heart, that the guardian would take them to the voting booth so that that would be ensured. Now, in the case of this interview that I saw, none of that apparently happened. And in that case, it would seem blatant that what occurred was not legal under the state statutes as I understand them.